What you're about to hear will shake the very foundations of American freedom. The Supreme Court has just issued a 9-0 unanimous decision on firearm confiscation, and the implications of this ruling are sending shockwaves across the nation. Yes, you heard that right. Unanimous, something we almost never see in today's divided political climate. What could possibly unite all 9 justices of the Supreme Court on such a controversial and deeply polarizing issue as gun rights? In the next few minutes, I'm going to break down exactly what this decision means, how it could change the interpretation of the Second Amendment forever, and why powerful groups are already pushing for an expansion of this ruling that could reach into your own home, your community, and even your right to defend yourself. But before we dive deep into this explosive story, I need your help. If you care about truth, freedom, and staying informed about what's really happening behind the scenes, hit that subscribe button and smash the like button right now. Subscribing doesn't just help this channel grow. It tells YouTube that you want to see more real discussions like this, instead of the filtered narratives the mainstream media keeps feeding you. Your engagement is the only way independent voices like ours can survive the algorithm that tries to silence dissenting opinions. Now, back to the story. Why did all 9 justices agree on something so controversial? What hidden legal precedent are they reviving? And how could this decision open the door for federal agencies to confiscate firearms without traditional due process? Some legal analysts say this ruling might set the stage for a nationwide review of gun ownership laws, while others warn it's the first step toward a government overreach that many Americans have feared for years. In today's video, we'll uncover the real motives behind this decision, the political players quietly celebrating it, and the immediate response from constitutional scholars and gun rights advocates who are calling this a ticking time bomb for personal liberty. So stay with me until the very end, because the final revelation in this story will absolutely shock you. And don't forget to comment below. Tell me what surprised you the most about this Supreme Court ruling. Was it the unanimity of the justices, the potential for expansion, or the eerie silence from the media? Let's get into it. 1. The unanimous bombshell. What exactly the 9-0 decision said and hid. Imagine all 9 Supreme Court justices, from conservative to liberal, shocked the country by speaking with one voice. That's what a truly rare 9-0 unanimous decision achieves, making it harder to dismiss or water down the ruling. In the case at hand, the court struck down the notion that law enforcement may carry out warrantless firearm confiscation inside private homes under a community caretaking exception to the Fourth Amendment, i.e., entering a dwelling and seizing guns without a warrant based only on concerns of safety or public welfare. This decision reaffirms that the core protections against unreasonable search and seizure extend to firearms in the home, a fortress of personal security. The court held that even in highly charged, emotionally fraught situations, the government cannot sidestep the warrant requirement without clear and historically justified exceptions. What's explosive is what the majority opinion avoided. It did not set out a broad standard defining every scenario in which firearms might be taken without a warrant, leaving open gaps and ambiguities that powerful actors may exploit. Hence the current push for expansion by law enforcement or legislative wings hungry to test how far this ruling can be stretched. 2. Historical and constitutional foundations. How this ruling links to precedent and the Second Amendment evolution. To fully understand the power of this decision, you must situate it in the long trajectory of constitutional doctrine. The Supreme Court in District of Columbia versus Heller first confirmed that the Second Amendment secures an individual right to possess a firearm for self-defense in the home. Later, McDonald v. Chicago extended that protection to state and local laws. Most pivotally, in New York State Rifle and Pistol Association versus Bruin, 2022, the court ruled that claims of constitutionality for gun regulation must align with historical traditions rooted in the founding era and early U.S. practices. In simpler terms, modern gun laws must have analogs in history to survive constitutional scrutiny. This new 9-0 decision draws strength from that standard. By insisting that warrantless firearm seizures lack historical analogs, and thus violate core Fourth and Second Amendment guarantees, the court anchored this ruling in the same tradition-based methodology. But, and this is critical, by not fully mapping every exception or edge case, the court implicitly invites future litigants and lawmakers to test those boundaries aggressively. 3. The expansion movement. Who's pushing, how, and why this ruling could be stretched beyond its core. Now comes the dramatic twist. Some factions, law enforcement agencies, prosecutors' offices, red flag law advocates, and gun control proponents are already eyeing this decision as a stepping stone. Their strategy? To argue for narrowly tailored expansions under exigent circumstances, mental health crises, domestic violence calls, public safety grounds, or judicial pre-authorization protocols, all without full warrants. They may push states or Congress to craft statutes that manipulate wording to appear constitutionally permissible under the new ruling. Critics warn that such expansions could hollow out the protective core, converting this decision into a Trojan horse for broader government overreach over gun rights. We might see attempts to authorize suspensions or seizures with ex parte court proceedings, predictive policing triggers, or even automated safety assessments without adversarial hearings. The immediate danger is not total confiscation, but creeping incrementalism, where each new exception chips away at the right to firearms in the home. 4. Legal battlegrounds ahead. Cases already in motion, unresolved questions, and constitutional pressure points. This ruling opens the door to a cascade of new litigation. For example, federal statutes like 18 U.S.C. Section 922G, disarming unlawful users of controlled substances, are under challenge. Courts are already asking, is it constitutional to disarm someone for past drug use when they are not actively impaired? Under Bruin's test, the government must show historical support for such disarmament rules, something critics say doesn't exist. Also, in United States v. Rahimi, 2024, the court upheld restrictions on firearm possession by individuals under domestic violence restraining orders, but that decision was plural, 8-1, not unanimous, and left open how far the government can go in creating disarmament categories. With the new 9-0 ruling as a constitutional lodestar, plaintiffs will argue that many existing statutes are unconstitutional in their sweep. Further complicating matters is the issue of ghost guns and weapon parts kits. In Bondi v. Vanderstock, 2025, the Supreme Court upheld regulation of kits that can be assembled into functioning firearms, rejecting a facial challenge to ATF's rules. That shows that the court is not completely hands-off. It's calculating which regulations survive under a historical lens. Another pressure point is the takings clause. Private property seized without compensation arguably triggers Fifth Amendment scrutiny. If governments confiscate firearms without a warrant, is that an uncompensated taking? This new decision may force courts to grapple with valuations and compensation claims in gun cases. 5. Political and social flashpoints. Power, narrative, and the fight for public perception. This ruling doesn't exist in a vacuum. It's arriving amid the most polarized gun debate in modern memory. Gun control advocates will portray this as the Supreme Court solidifying protections for gun owners. Critics will say it hamstrings law enforcement ability to prevent mass shootings, domestic violence tragedies, or suicides. Expect heated battles in state legislatures, arms of government agencies, and in media narrative. Pro-confiscation voices will press guilt by association. If someone was flagged as risky, they will argue authorities should have broader powers to act. Meanwhile, gun rights advocates will trumpet this decision as the strongest possible validation of home defense and privacy. One flashpoint will be so-called red flag laws, which allow courts to order temporary disarmament of individuals based on threat assessments. Proponents will test whether red flag orders, after judicial review, survive scrutiny in the post-9-0 world. Another battlefield. Local police departments asking for expanded conditional seizure powers during crisis calls. How far can they push under this new ruling? Moreover, public sentiment will be manipulated through fear. if authorities ground the narrative in preventing suicide or stopping domestic violence, ordinary citizens might tolerate incursions they would otherwise reject, especially if they believe it's for safety. The key will be how each side frames the story. Liberty versus safety, preventive policing versus property rights, common sense regulation versus slippery slope to tyranny. 6. What this means for you and your rights. How to stay alert, what to watch, what we might discover last. Here's where the rubber meets the road. This 9-0 decision protects your right to keep guns in your home without fear of arbitrary seizure. But that protection is not bulletproof. If lawmakers or law enforcement push expansions cleverly enough, future exceptions may erode that core over time. What you should watch. New proposed red flag laws, state bills granting seizure powers in psychiatric emergencies, legislative attempts to codify exceptions with vague language, and judicial opinions invoking public safety as a catch-all emergency. Also, watch how lower courts interpret this decision. Some will stretch it beyond its narrow facts. Others will clamp it tightly. Especially watch constitutional challenges to statutes in your state or district. Be vigilant about government intrusion, warrants, due process protections, and the requirement that any seizure be narrowly tailored, historically justified, and subject to adversarial process. Finally, here is the last, shocking revelation you cannot miss. Because the court left open uncertainties and did not explicitly address exigent circumstances tied to mental health emergencies or domestic threats, there is now a legal power vacuum. That vacuum is an invitation, an open alarm bell, to agencies, prosecutors, mental health authorities, and even private contractors to propose frameworks for weapon seizure that appear constitutional yet exploit the ambiguities the court declined to resolve. In short, the ruling may be solid, but the battlefield is now in those gray zones. Zones where your rights may be tested, eroded, or reinterpreted unless vigilance and legal pushback hold the line. So keep your guard up, stay informed, and be ready to challenge anything that oversteps the sanctity of your home. So don't forget to subscribe, like, and leave your comment about what shocked you most about this decision, and I'll see you in the next video.